this Petitions Committee meeting. I want to welcome all the members, all of the officials joining us, as well as the WCPP staff that makes these meetings possible, as well as any guests joining us on YouTube. Just a reminder, the rules of Western Cape Provincial Parliament online conferencing ask that we mute all participants. In the interest of keeping our bandwidth, using it sparingly, I'm going to request that you keep your video off unless you are speaking. You're more than welcome to put it on. Please also use the chat function if you'd like to raise a point of order, or if you'd like to get the chair or presenter's attention. Or you can also just identify yourself and raise your point of order. I'm now going to ask that members of this committee please introduce themselves.
Good morning, Chairperson and members. Wendy Philander.
Good morning, Chair. Good morning, Chairperson Khalid Sayed.
Good morning, Chair Lorraine Botha.
Good morning, Chair and members. Mesuli Kama, alternate member to the committee.
Good morning, Chairperson Regan Allen.
Thank you very much, members. So just for the record, I've had to check this morning. So the membership of this committee has changed slightly. So the members include members Bosman, Allen, Botha, and then member Syed and member Makamba Boycha. And then our alternate members are members America, Mackenzie, Kama, and Kleho. So member Philander, you're just joining us because you miss us.
Yes, Chair.
That's good. But you're always welcome. It's always good to have continuity as well. Colleagues, as you know, we haven't had a meeting in a while, and there's been some uncertainty in terms of which rules we are operating under, as the Petitions Act was never assented into law. What has then happened is the Speaker has used the rules to create a set of guidelines for us to operate as. And what we thought of as a good start of the petitions work again is for us to today to get a briefing by the Western Cape Provincial Parliament's legal unit. And we've asked Advocate Leroux to brief us today on the non-commencement of the Western Cape Petitions Act and any implications that that has for our work. Then we will move on to a discussion and question and answers on that. And then we've also asked the WCPP's Directorate for Parliamentary Support Services. We've got Mr. Stamele that's coming to brief us on the directives on petitions and executive undertakings, which was ATC'd in July of this year. And then we'll have a discussion on that. So without any further ado, I'm going to ask that the official from the WCPP's legal unit, Advocate Leroux, if you could perhaps start off with your presentation.
Good morning, Chairperson. Good morning, members and colleagues. Chairperson, thank you for the opportunity. I'm just uploading a presentation quickly, if I have control. I seem to have. Chairperson, is that presentation visible?
Yes, it is.
Okay. Chairperson, good morning. As you've indicated, I've been asked to brief the committee on non-commencement of the Act. I think this presentation is mostly an introduction to the later presentation by Mr. Stamele, in as much as it basically just gives the context or the background for the directive. Briefly on that, Chairperson, in June of last year, we became aware of the fact that the Western Cape Petitions Act had not commenced. Since it doesn't have a commencement date that has been proclaimed by the Premier, we were in fact alerted to it by one of these organizations that collate laws, etc., for general public access. And they contacted us at some point to ask where the commencement notice is. The Directorate Legislation and Legal Services Department of the Premier confirmed certain facts. They confirmed that the Act was published in November 2006. Section 9 of the Act provides that the Act comes into effect on a date set by the Premier by proclamation, as is usually the case with provincial laws. Regulations in accordance with the Act were issued by the Speaker. That was in 2010. And the Directorate also confirmed that there is, in fact, no commencement notice. Briefly on that, it follows, I think it's quite obvious then that the Act has never come into effect. It doesn't have legal effect, it never had legal effect. And it also follows that the regulations that were issued, and of course regulations are issued in accordance with an Act. If there's no Act in place, then the regulations cannot have legal effect, and it never had legal effect. So shortly, the Act and the regulations are pro non scripto, which basically means that it is as though it has never been written. Just some comments on the legal effects of non-commencement of the Act. Maybe I can observe it is difficult to assess these things in the abstract, and it's sometimes difficult to to foresee what the possible outcome could be. Nevertheless, so since 2006, this legislature, under the impression that the Act has commenced, purportedly implemented the Act. As the members know, petitions were received and processed in accordance with the Act, or purportedly in accordance with the Act. It's difficult, as I said, to assess the possible legal consequences, but it does not appear at this stage that as though non-commencement of the Act will be particularly consequential for reasons which I will go into a bit, or that it will present any significant legal risks. I think importantly, in accordance with Section 115 of the Constitution, a provincial legislature or any of its committees may receive petitions, representations, or submissions from any interested persons or institutions. The Act, therefore, does not impart any particular power on this legislature to do something it would otherwise not have been empowered to do. It is the Constitution that imparts the power to receive petitions on the legislature. So briefly, and this power is basically an extension of the legislature's general power to have oversight of the provincial executive and provincial organs of state. A petition is an avenue by means of which any interested persons or institutions can access, in a manner of speaking, the oversight authority of the legislature to look at a particular issue of concern, provided, of course, that issue is in the oversight mandate of the legislature. It follows then that non-commencement of the Act does not in any way diminish the legislature's authority to receive petitions. So that authority still exists. It existed before the Act seemingly or purportedly came into effect, and it still exists. What the Act focused on or purported to achieve was to stipulate procedural requirements and requirements of form in respect of the making and processing of petitions. So the focus wasn't as much imparting any authorities on the legislature. The focus was more on the how of how petitions should be submitted and what the contents of petitions should be and those type of things. The power to receive petitions has always been there, regardless of non-commencement of the Act, and the bringing of petitions to the legislature has always been legally competent. Chairperson, just some of this is maybe more in a legal analysis perspective, but the question is, should the Act now be brought into effect? I think once we became aware of the fact that the Act did not commence, I think the obvious solution at the time seemed to be, well, let's simply ask the the Premier to issue a proclamation or a commencement notice. My advice is that should not or cannot be done, briefly for the following reasons. It may be fortunate that the act has never commenced. In 2011, the Constitutional Court, in the judgment in Premier Limpopo Province, etc., the full citation is there, considered the legislative powers of the provincial legislatures. I think the members are probably well aware of what we briefly call the Limpopo judgment. That judgment was specifically relevant when it came to financial management laws that the provincial legislatures passed, and then the issue was whether the legislators have the legislative power to pass that type of laws. It is inferred from an analysis of the Limpopo judgment that a provincial legislature does not have the legislative authority to make a provincial law on the processing of petitions. Hence, had the Act come into effect, it would likely have been unconstitutional. In paragraph 21 of the Limpopo judgment, the court explained that unlike Parliament, which enjoys plenary legislative powers within the bounds of the Constitution, the legislative authority of the provinces is circumscribed. And then the court proceeded to consider what the exact scope of the legislative authority of the provinces is. Section 104, which I paraphrase slightly here, provides that a provincial legislature may pass legislation for its province with regard to any matter within a functional area listed in Schedules 4 or 5, any matter that is not within a functional area listed in Schedules 4 or 5, but that is expressly assigned to the province by national legislation. I'm sure the members are well aware of these provisions as well. And I think for our purposes, paragraph C is the important one. Any other matter for which a provision of the Constitution envisages the enactment of provincial legislation. And as is often the case in the law, that word envisages, which I put in italics, to quite a lot of debate to sort of flesh it out and to determine exactly what it means. Just briefly, petitions is not a matter within a functional area listed in Schedules 4 or 5 of the Constitution, and it is not a matter expressly assigned to the province by national legislation. So the only way a province can have legislative authority would then be in terms of that paragraph C, which I referred to earlier. So what must be determined is whether petitions is a matter in respect of which the Constitution envisages the enactment of provincial legislation. And this is exactly what the Constitutional Court looked at in the Limpopo judgment. What is the scope of that word envisaging? Okay. Then in paragraph 52 of the Limpopo judgment, it was said, it seems to me, that only those provisions of the Constitution which in clear terms provide for the enactment of provincial legislation must be held to fall under section 1041, etc., meaning that it is cases where the Constitution envisages enactment of provincial legislation. Also, for further context, in paragraphs 53 and 54, the court stated that the Constitution furnishes us with examples where provincial legislation is envisaged. One example that immediately comes to mind is section 1555, which provides that provincial legislation must determine the different types of municipality to be established in the province. As I've mentioned also earlier, in respect of petitions, with determining the different types of municipality to be established is neither listed in Schedules 4 or 5, nor is the matter with respect to which provinces have been expressly assigned legislative authority in accordance with national legislation. But that is nevertheless a matter with respect to which the Constitution envisages provinces enacting legislation. I also think we are all well aware of the further example in that quote, which is section 123 of the Constitution, which provides that a provincial act must provide for a procedure by which the province's legislature may amend the money law. And then the court says there are other examples, and also in the footnote, then the court refers to those specific examples of where the Constitution envisages provincial legislation. Long story short, petitions is not a matter in respect of which the Constitution envisages provincial legislation. From the above, on paragraph 12, petitions is not a matter in respect of which provincial legislatures have legislative powers, and that being so, I do not advise that arrangements be made to have an act come into effect, which act would likely be unconstitutional. Chairperson, this presentation is based on advice I prepared a bit more than a year ago. And at the time, I made certain observations and certain recommendations on the way forward. I think Mr. Semele will give us more guidance from a procedural perspective as to where, as an institution, we are in terms of dealing with non-commencement of the Petitions Act. I'm going to refer to the recommendations here, but I also appreciate that these are still things that needs to be decided, presumably partly by this committee, on a policy level as to what the way forward would be. I start with section 115 of the Constitution, which makes it clear that a provincial legislature or any of its committees may receive petitions, representations, or submissions. And then also importantly, section 116 of the Constitution, which provides that a provincial legislature may determine and control its internal arrangements, proceedings, and procedures, and make rules and orders concerning its business. We have established that a provincial legislature cannot make a law to provide for petitions. The legislature can, however, provide for petitions in accordance with section 116 of the Constitution. And in terms of section 116, there are many mechanisms by which the legislature can do that. That may include policy or directives or rules and orders. I point out with reference to the standing rules, Rule 111 plus Rule 4, which already provides, as is, that every standing committee may receive and consider petitions, representations, or submissions from interested parties. So that entitlement, let me say, of standing committees to receive petitions is already in our standing rules, and it's still in our standing rules. And in respect of the general powers of committees, I also refer to Rule 91, paragraph E, which acknowledges the power of all committees, so committees, including standing committees, to receive representations, including petitions. On paragraph 9, Rules 91 and 111 of the standing rules, together with section 115D of the Constitution, already creates an avenue for petitioners to bring matters to the attention of parliamentary committees. And of course, provided that those matters are within the mandate of the legislature and also in the mandate of whichever particular committee. As far as the processing of petitions is concerned, Rule 91 of the standing rules empowers all committees to determine their own internal procedures. Petitions are in essence a request by an interested person or institution that the legislature exercises oversight of a particular matter in that legislature's mandate. In the advice at the time, and this is still my view, I'm not of the view that there's any need for a different or unique system of oversight to be created in respect of oversight matters that come to a committee's attention by means of a petition. And then I suggest that there may be greater efficiencies for a legislature of our size to process petitions within the existing standing committee system, which is already well equipped, I would say, to deal with oversight of the provincial executive and provincial organs of state. Chairperson, that is my presentation. I'm happy to answer any questions if there are any.
Thank you very much, Advocate Leroux. Colleagues, I'm now opening the floor for any questions. If you could indicate by raising your hand if you've got any questions on the non-commencement of the Petitions Act. I see no hands from any of the colleagues. Honourable Botha, you may go ahead.
Thank you very much, Chair. Through you, I just want to get clarity for myself in the presentation and the notes that I read, that this standing committee then proceeds in the way that it has previous to this presentation. I just want clarity.
Advocate Leroux, you may answer.
Chairperson, I think on that issue, it's better for Mr. Stemele to answer that question, because as I understand it, Mr. Stemele's presentation will focus on where we are now and what has been put in place for the committee to continue its work. Is that in order?
Okay, so we will hang on to that until Mr. Stemele has presented. Colleagues, are you okay for us to go on to Mr. Stemele's inputs and then take questions after that?
Yes, Chair. I was going to remember Kama, sorry, Chair, if I may. I was going to suggest that, Chair, maybe we go to the second presentation. Then, if there are questions that perhaps even Advocate Leroux can assist on when we have received that other presentation, then we'll be given that opportunity. Thanks, Chair.
Perfect. Thank you very much, Member Kama. Mr. Stemele, we'll then go over to you. So we've now gotten a background and understanding of the non-commencement of the Petitions Act, and now we are going to have a look at the rules of engagement going forward. And these were rules ATC'd by the Speaker. So, Mr. Stemele, I'll hand over to you, sir.
Thank you, Chair. Good morning, honorable members and colleagues. I'm trying just to upload or to share my presentation with the committee now. It doesn't seem to be. Okay. I'm not sure if the presentation is shown clearly, honorable members. Are you able to see my presentation?
Yes, we can. You can just enlarge the screen to full screen. Okay. And then we should be able to see it.
Okay.
We can see how it's clear.
It's clear now?
Yes, it is. You may continue.
Okay. Honorable members, I'm not going to go dwell much on the background. Advocate Leroux has already given it. But it's safe to say, having considered all what he has said, the Speaker showed the desire that we need to move swiftly in ensuring that there is an instrument that is in place. And upon discussion by the procedural hub of the institution, then we said to enhance also the oversight role of the Petitions Committee. It should not just be petitions and then thereafter what's going to happen. Let us also try to nip it a bit in the bud and include the executive undertakings. I will explain later on as we go down what are the executive undertakings and how differ are they to the petitions, and probably when and where are they being given. But also, Advocate Leroux, I'm not also going to dwell on much on the legal framework that Advocate Leroux has already set dwelled much on it. But I would say that this is also in terms of the Rule 115 of the petition of the standing rules of the Parliament, that states for the Petitions Committee is composed in accordance with Rule 78. But I just want to go straight to the definitions now. Now, when we sat down and analyze this, we said, probably let us define what will be the petition, what will consist the petition, and what will be regarded as a petition. and how is this petition supposed to be submitted. Same applies with the executive undertakings. So I've crafted my presentation here just to show the elements of it, that the petition is a formal written request that is signed by one or many people. It must comply with the requirements stated in the directives, which I'm going to explain later, must be appealing to the WCPP in respect of a particular cause for intervention in a particular matter. It can take the form of either of a request for assistance with specific issues or of request for redress of a grievance. However, it excludes issues that fall outside the jurisdiction and mandate of the WCPP. Now, the question becomes, what happens if a person cannot write, comes to WCPP and say that, you know, I've got a petition, I've got a grievance, I need assistance. Now, in that, we've got an SOP that is still being drafted that says in an event of a walk-in, that will be able to take a person, we assist a person in penning down that particular petition, and then it be channeled through the proper processes internally as they will be defined by the SOP that is being drafted. Now, what happens thereafter? The petition will take place, it will be investigated, everything else. Probably the member of the executive that is being, or his or her department that is being affected by this petition would come and make an undertaking. Now, what will be an undertaking? It is a commitment. It is a promise and assurance made by the member of the executive during the sitting of the WCPP and related to issues ancillary to oversight will be included for the members to address, including issues related to integrated approach to governance. Basically, what does this mean is that now when a member will say, okay, we are responding to this in the house, let's say this has been tabled down in the house or in the committee, and said that, look, we're making an undertaking as a department that on this particular date, we'll do A, B, C, D, E towards this particular grievance or petition that has been rendered. But this has to be, now, this is what the thing, it has to be in the sitting of the WCPP, not outside the sitting. This is where the difference will be. It cannot be made anywhere, let's say, in a public meeting, or it has to be the sitting of the WCPP that is constituted by WCPP, not just a public meeting. And it has to relate to issues that are raised or are ancillary to the said particular petition. It cannot be something that is outside to the petition that has been said, that has been filed. It has to be something that either relates to it or it's ancillary. But either as that as it may, now it has to fall within the mandate of the WCPP. That means it cannot be falling under the mandate of the municipality. It cannot be falling under the mandate of the national government, but it can fall within the department or within the entity established by a department of the Western Cape government. Now, what will be the undertaking register? Because when these have been done, we have to register them, we have to be able to follow up on them. Now, we have to create now what we call an undertakings register. Now, this is a list of issues raised by communities in the petition itself and the executive responses and the commitment to address those issues. The register must note the lead minister, which means if there might be issues like the issue of school, like there is a school building that we need school to be built and all that. But this is an issue of education department and also Department of Public Works and Transport. But the lead department in this instance will be education. So it will be said the lead department is Department of Education, and the other department or the court department that assists here will be Department of Public Works and Transport. So that it can be clear that this is, yes, the mandate of this department, but it has got other players around it so that it can be able to be followed up by this. And the mandate of another department who undertakes to respond to the issues with clear timeframes and reasons for non-response or mitigation matters. Now, also it goes back to what most committees currently are doing, tracking the resolutions of the committee. But in this instance, we'll be tracking now the undertakings that have been made through those particular timelines that have been given. So this also brings in a new element of saying, when you do this, you don't just say we'll do this A, B, C, D, E. There must be timelines so that we're able to track this. Because one of the problems that frustrates communities lately is the issue of not being responded to at a time where they were promised that they will be responded to. So it's very much important that if we would to do this, we'll be probably trying to bring a sort of stability within our communities. Now, moving, Chair, to the requirements for the petition. I've spoken there. What will be the requirements? It must be submitted in the prescribed format in accordance with the WCPP directives. It must contain the details of the petitioner or petitioners, clearly identify the issue or issues, and be signed. But the reality of the matter is that not everyone or not every people might be able to write clearly and concisely. So it means that when this petition has been received, there should be probably some preliminary work that would be need to be done, so as to be able to sift what are the issues that are being raised, so that we don't conflate issues, we don't bring everything that is not really an issue, but we have clear issues that will be stated, so that we can have a clear petition that says that committee, here is the petition, this is what the redress that is being sought by these particular petitioners. Now, the petition itself must be submitted to the WCPP by registered mail, by email to a designated email address, and in a case where it is submitted to another email address of the WCPP, that office must forward the petition to the petitions office within 3 days, which is working days in this sense, and by walk-ins, in or delivery by hand to a designated official of the WCPP or committee for the WCP or the office of the speaker, on the website or mobile application of the WCPP. Some of these things are not things that are already clearly available currently, but this is the state also that we're envisaged to move towards in the near future. However, by registered mail, it's already available. Through a designated email address, it's already available. In a case where it is submitted to another email, this is what the SOP will deal with, how that should be dealt with. By walk-ins, what I've spoke about earlier on, giving assistance to people that came in and lodge a complaint, and also to be hand-delivered to a designated official. It can be also to the committee itself, which is the petitions committee, or it can be delivered to the procedural officer that provides supports to the committee, and he will redirect it to where it is needed to go, or to the office of the speaker. But these will be probably the officers and officials that are in the eyes of the public. And then on website, which is, it's a matter that we're still busy with COSB and the IT guys to make sure that at least we open the tab that allows members of the public to upload their petitions. Now, the petitions made to the WCPP will fall within. Now, this is the final requirement, that it must be within an area that the WCPP has the power to legislate on or falls within its jurisdiction or mandate. The failure of members of the executive to address issues raised by the community through the relevant channel in his or her department, the petitions, okay. The failure of the member of the executive to honor the commitment he or she undertook during his or her community outreach program that forms the basis of the petition, and the exhaustion of all avenues available to citizens for the resolutions for the complaint or petition. This means that a person cannot simply just jump and say that the department has not given us the school. The Department of Education has failed to admit my child on the central application system. And now I'm launching a petition with the committee. But what are other avenues that have you gone through? You must have exhausted all the possible avenues. Then this will be the last avenue, but provided, again, this is another provision that is very much important. The matter is not in courts. The matter is not being investigated by the public protector. The matter is not being in the desk of Human Rights Commission or any other Chapter 9 institution. That is something that is very much important that we need to accept, which is, it takes us to another point, that which petitions will not be considered by the committee. It will be matters that falls outside the scope referred to in paragraph 4 of the directives. Anything that interferes in the matter that are subject to judicial proceedings, are subject to investigation by Chapter 9 or 10 institutions, are subject of an investigation by the state security agencies, or is currently being investigated by a commission of inquiry appointed by the president or the premier of the Western Cape. Now, all these things are subject to these provisions. They must not be falling outside the scope as referred to in the directives. They must not seem to be interfering with any judicial proceedings, must not be investigated by Chapter 9 or 10 institutions, state agencies, or commissions of inquiry. Now, I'm not sure whether members are really interested to go through the administrative process of the petition. Can you indicate, Chairperson?
Please go ahead and outline the process briefly.
Okay. The Petitions Committee must, now this is not may, this is what it must be done by the Petitions Committee after having received the petition and the briefing from either from the researcher or the petitions officer or whoever would have done the preliminary report. Must be supported by the dedicated administrative staff with the following duties but not limited to: conducting preliminary investigation into the petitions, including but not limited to the seeking of legal and other advice, language services and relevant documentation, providing administrative support to the committee through the processing of the petition, document and incorporate in the committee report the executive undertakings, ensure the report is adopted by the legislature before the final outcome is communicated to the petitioner. Communicate to the petitioner the findings or reports of the committee and communicate through the secretary to the WCPP to the petition, the final outcome of the petition processes, and advising the petitioner of further steps that could be taken by the petitioner. So clearly now, these are the core things that we need to do in ensuring that we reach the desired outcome, or at least conclusion of the process. And these are the support systems that need to be in place for the Petitions Committee and some of the things that have to be done. That means the report now we envisage a state where the report will not just end within the committee itself, but to the extent that it becomes adopted as a report by the House itself, say, these are the reports that we have as the Petitions Committee, then they have to be adopted. That provision, I know that it's not commonly done currently, but we're working towards that in our new oversight model that we're working towards. So I assure honorable members, this will be realized sooner. Now, the role of the Petitions Committee. The Petitions Committee may conduct oversight visits to establish facts as a follow-up to the submitted petition, must act in a transparent and accountable manner, must resolve a matter through a process of conciliation, mediation, or negotiation, must consider petitions referred to it by the Speaker, and must submit to the Speaker the findings or outcomes of the committee, consideration of the petition, and executive undertakings made by the member of the executive. And the Speaker must table the report in the Western Cape Provincial Parliament for consideration. Now, the scope of the executive undertaking now, finally, is that any matter that falls within the mandate of the relevant member of the executive, that means a member of the executive cannot make an undertaking for something that doesn't fall within the scope of it. It has to fall within that scope of that member. That means the member must be the political head of that particular area, so that can be able to make an undertaking for that. If the matter is outside of his or her mandate, but within the mandate of the provincial government, the member of the executive must forward the matter to the relevant member for consideration and report to the provincial parliament. Lastly, honorable members, basically this is just what the register of the executive undertakings should look like. This is just now just for visual enhancement. This is how it should look like. I know that probably now the question becomes to the honorable members. This also talks about the responsibility of the executive. How are they going to understand what is expected of them from now on? Honorable members, we did sit again with the secretary and the speaker to discuss the matter, in fact, the speaker's office. And we're of the view that probably we need also to arrange another session wherein we'll be presenting the obligations of the executive to the leader of government business office, that probably then can be able to ensure that we get an audience with the members of the executive to present what is expected of them in terms of the directives, so that we can all be on the same path in this instance. Chairperson, thank you very much.
Thank you very much, Mr. Stemele. I'm now going to open it up for questions from members. The first one will be from me. Mr. Stemele, you mentioned that it needs to be petitions on issues that fall within the ambit of the provincial government. But what happens when there's a concurrent mandate, as has been in the past, where we receive petitions that also impacts on the work of national government?
Chair, one of the things that we have to look as to what will be our role. Are we the lead, as it would be? Are we the lead in this petition? If we are the lead, then we'll take a leading role and seek also intervention from national based on our role being the lead. However, if we are not a lead, this is what probably we need to be looking at, whether aren't we then supposed to have a link with the NCOP Petitions Committee to say, look, in an instance where we receive petitions that have a concurrence jurisdiction, but the lead is a national department, then we channel those to the NCOP so that they can be the ones that are dealing with it. And then we just provide ancillary support and reporting, probably provide the reporting lines towards back to the petitioners. But it's something that needs to be looked at.
Thank you very much. I see Member Kama. Member Kama, please go ahead.
Yes, sorry, Chair, I was struggling to unmute, sorry. Chair, my question is also slightly close to your question. But I want to understand, I understand in terms of the national government, and I think the Chair has asked the question that I wanted to ask, where really you would find that we also have a mandate on something that, or oversight on something that the national government also has mandate on. But I want to get more clarity, Chair, in terms of the local government. I've been trying to look perhaps maybe issues, in the past we have been dealing with also, I think there was a petition that also concerned a certain municipality, if I'm correct. But I'm saying, what if we can be told as to maybe some sort of an example of a petition or issues that we can't deal with because they fall within the mandate of local government, understanding that we ourselves in the province also have a responsibility to support and strengthen the capacity of municipalities to manage their own affairs. So I just want to check as to what really would be out of our scope in terms of local government, if a person would have tried, to go and use other avenues in that space, but even at the point of submitting the petition to the, using the petitions committee as a last resort because they've tried all other avenues. So I just want to get really clarity around the issue of the scope. And also, I might have missed it. Sorry if I missed this. But I want to check in that as to where does the responsibility lie to really check what is the process, in detail, to check if this is really within our scope. Is it something that is going to be done by someone who receives the petition, or is it going to be done through a particular process that involves more than one person? And not that you doubt, but just to ensure that really justice would have been done, in terms of assessing whether that petition falls within our mandate. Thank you very much, Chair. Otherwise, I want to welcome the presentation. They were very much clear.
Thank you very much, Member Kama. Sister Miller, do you want to go ahead and answer that?
Yes. Chair, some of these will probably be political decisions, but by law, the law is clear on it, that there are 3 spheres of government and one cannot interfere on other unless it has to apply Section 100 or some of those provisions of the Constitution. I'm not wearing my legal hat now, so that's why I'm not even thinking about them. However, I always say the most important thing is, the issue of petition it's another way of enhancing public participation process through the governance generally in all the 3 spheres of government. So the most important tool is to ensure also that, among the legislature or the parliament, Western Cape Parliament itself, creates through the spirit of intergovernmental relations, those relationships with with all the municipalities within the Western Cape, and ensuring in the process that they indeed have that relationship to say, look, this is the petition that falls within you. Can you please understand and undertake to come back to us with the answers? Or through the Department of Local Government and Traditional Affairs, say, look, we've received this, and then you have the lead department that provides support to these particular municipalities. Then go and seek answers and provide assistance in terms of resolving certain issues. Because other issues may be issues that indeed require intervention of the provincial government, that at the end of the day, upon the committee have investigated that particular petition, would really find that indeed these are requiring intervention now as stipulated within the Constitution. So those are the things that have to be considered. In terms of who decides that this falls within or not, when the petition is being received, it is assessed. A report with the petition itself is submitted to the committee. That is, an administrative member of the committee that provides that administrative support cannot decide on its own whether the committee can discuss or cannot discuss this petition. It is still the decision of the committee to say, yes, we can discuss, no, we cannot discuss, and provide reasons for that. And where possible, then redirect it to where it's supposed to be addressed. Thanks, Chair.
Thank you very much. So that is still very much done by the Public Education Outreach Office, am I correct?
Yes.
Perfect. Colleagues, are there any other hands or questions? Member Allen?
Thank you, Chairperson. I just wanted to double check. I've noted in the presentation that it is mentioned that an official, there's an administrative person that will help the committee in order to do preliminary investigations, etc. Would such a person already be in the administration? I sense that should petitions pick up, and I know this is probably an administrative question, that the procedural officers would already be overburdened by the committee work, and would this be a separate person, and would this person be in the education directorate, the outreach directorate, that would do all the preliminary work and engagement as per the presentation? Thank you.
Perfect. Thank you. So, Mr. Stamele, can you just confirm that the procedural officer is not doing any of the preliminary work, but it will be done by the PEO directorate?
Thank you, Chair. Chair, as things are being envisaged now, it's the PO and research. The PO will provide his or her input to research, and research will do the preliminary investigation where possible, and then it will be reported. The committee will be given a brief thereafter.
Perfect. Thank you very much.
Yes. Remember, at that stage, Chair, I just want to explain something. At that stage, it is still at a submission stage. So the committee receives the brief, it receives the brief now and receive the petition as a committee. Then it takes it from there. Then it becomes the responsibility of the committee thereafter.
Thank you very much. Colleagues, can I see, are there any other questions that you have on both presentations? Just for the last time, I'm going to ask again, are there any other questions that anybody has on the directives for executive undertakings or on the presentation by Advocate LaRue on the non-commencement of the Petitions Act? I don't see any other hands. So with that, I'd like to thank Mr. Stabela as well as Advocate LaRue for your time this morning and for providing some clarity to this committee. As testimony by the very few hands we had this morning, your presentations were very clear and well understood. So thank you very much for joining us today. You're welcome to stay on, or you can get on with anything else that you needed to do.
Thank you, Chair. Unfortunately, I've got a meeting. I would have loved to stay, Chair.
Enjoy that.
Thanks, Chair.
Thank you, Chairperson.
Thank you very much. Colleagues, we're now going to then move over to the draft minutes of our meeting, our last meeting on the 28th of August 2020. And I just wanted to ask, Wasima, are you able to pop that onto the screen for us?
Chair, can you see it?
Yes, I can. So, colleagues, this was the last meeting that we had on Friday, the 28th of August 2020. And the first page being tabled is the attendance. If you remember correctly, this was a meeting with the petitioner, Mr. Barry Jacobs, on the Powertown petition, as well as Dr. Wayne Alexander from the Land Restitution section of the Lands Claims Commission. And this is one of our ongoing petitions that we're still trying to get to the bottom of. So the first page is being tabled. If there are any amendments or additions that you'd like to make, please let me know. And then we're going to page 2. So these were the resolutions that the committee took. It was to undertake a fact-finding visit to Mossel Bay and Powertown to look at the parcels of land in question and to engage face-to-face with the petitioners. It was also to engage with the municipalities, Mossel Bay municipality, and the petitioner, as well as the commission, to understand the process that was followed. As you remember, there were quite a few pieces of land in question, and only some work was done by the commission over a long period of time. And then also to request the public protector to provide the committee with the correspondence and documentation with regards to their communication with Mr. Barry Jacobs. Wasima, if I could just ask if we can correct public protector, just take the S away at protectors, as well as the S at correspondence. Here we go. And what we've also done is we then said we're going to ask that the commission for land restitution present to us on the process to submit a land claim. Also give us a copy of the file that they have on the petition submitted by Mr. Jacobs, as well as a spreadsheet containing the claim from each of these claimants of the Mossel Bay land, as well as the earth numbers and the amount paid to each recipient, as well as the current occupier or owner of the land and the land evaluation. And then we wanted a copy of that, the elusive research report that is used to determine whether a claim is valid or not. Members, are you happy with us adopting these minutes as is? If so, may I have a proposer and a seconder?
I move that we adopt, Chair.
Thank you very much. That's moved by Member Allen. Member Syed?
I'd like to second that, Chair.
Thank you very much, Member Syed. The minutes is then duly adopted. Members, we're then moving on to the committee's annual report. The draft annual report for the 2021-2022 financial year. So there we are just tabling page 1, which outlines committee membership. And as you know, that has now changed slightly. It also outlines our mandate. I'm not sure whether that paragraph is still valid based on the conversation we had this morning, because there is no Western Cape Petitions Act of 2006. And then it outlines the amount of meetings we've had. I love how quickly Wasima is moving away from that section. And then what we also have there is our oversight activities. So one of the outstanding petitions on our books is the petition by Mr. Barry Jacobs. So we've resolved to go on that fact-finding mission. And then we also have there the financial particulars of this committee. Members, Bosima, do we have to adopt this as well?
Yes, Chair, this has to be adopted. I will just seek clarity on that top part of the petition section, and then I will revert back to you. But the essence of it is there. It's just that introductory part of the act that I need to just seek clarity on.
Okay, member, may I then ask that we have a proposer and a seconder, noting that we may need to change the terms of reference for this committee.
Thank you, Chair. I move that we adopt and based on the comments from the procedural officer as well. Thank you.
Thank you very much. Member Syed, are you going to second?
Yes, I'm seconding that, Chair. Sorry, I was getting to my mic. Yes.
Thank you very much. So then, colleagues, just in terms of the next steps, myself and Wasima are going to see whether we can get the wheels in motion to start arranging that oversight visit to Power Town. And we will get in touch with you with regards to sort of a convenient time frame to do that, to visit Mossel Bay and to look at these things in its context, and also when we can get all of those role players together. Wasima, I see your hand.
Yes, Chair, thank you. On that you are just announcing to the members, I just need also, would that be one visit since it's in the same region, and then it will be done together, Power Town and the one to Mossel Bay, so that 2 days would be looked at on the parliamentary program to accommodate. I just need guidance on that regard from the members.
Members, are you happy with us doing both of those in the same visit instead of going back and forth?
Agree with that, Chair.
Okay, perfect. So members, are there any other business that you think we need to discuss? take that as a no. Wasima, I see we've got another meeting scheduled for the 27th. Can we agree that we will not have that meeting on the 27th? And that
Sure, Chair.
we will then just start planning the Mossel Bay trip to make sure that we do get on with concluding these two petitions, because it has taken quite a while.
No problem, Chair. I will look for the closest date in September for us to do that visit so that it gets done as soon as possible.
Perfect. Thank you very much, everybody. Thank you very much to Wasima and to Mr. Daza, as well as Mary Ann, Burgess, Candice and Siraj for putting this together. And also to all of the colleagues who joined us from the WCPP in providing information, both to Mr. Stemele and Advocate Leroux. And thank you very much to all of the members for joining us today, and very warm welcome to Member Botha, our former alternate, who's now a permanent member. You're going to have lots of fun with this committee, Member Botha, because it's exactly the same as the Education Committee, same people.
So I see, yeah, it's becoming a trend now.
So education and petitions will be doing their work together.
We might as well make just one chairperson.
And just have a petition meeting within the education meeting.
I think if we start telling schools and teachers that there's a petitions committee, they might bring all the education problems to this committee. So it might be good to collapse, but I'm just joking. Colleagues, thank you very much for your time. With that, our meeting is then adjourned.
Thank you very much, Chair. Keep well, go safe.
Enjoy the weekend, everybody.
Thank you. Thank you.
Thank you, Chair. Thank you, members. It's been a pleasure.
Bye-bye.
Thank you. Bye.